Welcome to Law Talk Today, a series devoted to bringing you informative and educational programs focused on issues of law, government, and community. Hello, and welcome to Law Talk Today. I'm Dan Agatino, your host. Joining us in studio today is attorney Adam Snukal. He's an expert in IP issues. Adam, thanks so much.
Thanks, Dan. Nice to meet you.
So we were talking off camera about IP, or intellectual property.
Right.
And I'd just like to start with my first question. What's it all about?
What's it all about? The $64,000 question, Dan.
Yes.
I think it's a good place to start because a lot of people, especially non-lawyers, really assume that intellectual property is really one type of property, but is given this grandiose name. But in fact, intellectual property is typically split up into three different areas, and maybe a fourth that we can talk about, but three generally. And they are copyrights, patents, and trademarks. And each one represents a different type of property or a different type of product. For example, copyrights covers everything from software, or could cover everything from software, to music, writings, poetry, even architectural drawings are protected under copyright. And then there's patents. Patents relate primarily to inventions, and they can cover everything from a business method, how something is done, to pharmaceuticals, to engineering, to the clasp of a piece of jewelry. All that would be covered under patents. And trademarks is primarily branding, things like logos and names that a company or a particular product bears, which the owner of the product wants to protect as its own. So all three areas are all covered under this definition of intellectual property, but each one is different. Very often I have clients who will say, how can I protect the copyright relating to the name of a company? And I say, no, actually that's a trademark issue, not so much a copyright issue.
So we see sometimes a little C with a circle around it.
Right.
That indicates it's copyrighted.
Correct. That's copyright registered.
And the difference between a copyright that is registered and a copyright that isn't is what?
Is a registration that's filed with the Copyright Office in Washington, D.C. To gain protection under a copyright, you don't have to have a registration, but by registering, the law gives you certain benefits. For example, the ability to defend it in court, the ability to collect attorney's fees, the ability to receive statutory damages. You still have the protection that a copyright affords you without registering it, but if you do register it, you get all of those same rights plus.
So sometimes we see something copyrighted. If there's a little TM after a word, it means trademark that hasn't been registered,
That's
correct?
exactly right. The same thing with trademarks. In trademarks, you could have common law rights, but then you could also have registration rights. If you use a particular mark in commerce, in what we call interstate commerce, that the product or the services are being used across state lines across the country, even without filing a registration with the Patent and Trademark Office, you still have certain rights that are granted to you in terms of not allowing or preventing others from exploiting the same brand or the same mark. However, if you register the trademark, or if you file an application to register the trademark, just like with copyrights, you're given certain additional benefits. For example, there's a presumption that you own the mark. There's a presumption that if you go to court and somebody tries to fight you on the mark, the burden is on the other party to show why they have stronger rights in that mark than you do.
So let me ask you in a practical sense.
Sure.
Let's say off camera, I'm a big-time rapper.
Yeah.
And I write all day long.
Right.
And I want to protect
right.
My music, my songs,
right.
my lyrics. How do I do that?
So that's a copyright issue. As I mentioned before, copyrights deal a lot with artistic works. So what you would do is you would take the song, take the material, and you'd file a copyright registration on the Copyright Office for that. Getting back to the trademarks, you might also want to think about filing an application for the name of your group, especially if it's going to appear on shirts and hats and mugs that kids take to school, all those different types of objects. That's where you're actually using a brand or a name in commerce. Okay,
so I do all that.
Yeah.
And now I want to know, my song sounds a little bit like somebody else's song. As a matter of fact, there is a sequence where there's 3 or 4 notes that are used in another song, 3 or 4 notes. Am I allowed to do that, or does it have to be totally brand new?
No, it actually, the standard for copyright infringement is substantial duplication. And the courts have decided, depending upon the different area of the work, what the word substantial means. So a court could very well find that using 3, 4, or 5 notes of another song, especially if they're part of the chorus, if they're a fundamental part of the song, that's a highly recognized part of the song, that even 4 or 5 notes could constitute copyright infringement.
So like the theme to Jaws, which is just a few notes, but it's known in society.
Absolutely.
You can't just throw that into a song.
You can't.
But if I have a couple of notes that someone else used in a sequence that's generic, everybody uses it, it's okay.
Probably harder,
probably safer.
Right, probably safer, probably harder to protect. But there's actually people in society, and all they do for a living is listen to songs, trying to detect those 3 or 4 or 5 notes that you mentioned. And once they think they found some unauthorized duplications, they bring it to the record label's attention. And there's actually like a fee that the record label will pay these people to bring infringements to their attention.
Okay.
So, for people who are out of work, it's a new line of jobs for them.
So now we know that C with a circle in it is copyright,
Right.
and R with a circle is a registered.
Right.
Trademark is a trademark that isn't registered. What's SM?
SM, service mark. That functions very similar to trademarks, except that it's for a service and not so much for an actual product. Trademarks are the rights that attach to a product.
Right.
Service marks are the rights that attach to a service.
Okay, so that's a primer. Now we have some basics of intellectual property.
Right.
What's the next step? Tell us a little bit about the difficulties that come up in your line of work.
Great question. I think the difficulties. Well, why don't we start with the typical company, what they come to us for, and what are the issues that we're presented with. We had spoken off camera about employers, the rights that employers acquire with respect to works created by their employees. The copyright law says that any employee who creates a work for an employer, those rights automatically belong to the employer. No agreement is necessary, no assignment is necessary. It's still probably a good idea to have those pieces of paper, those agreements in place, but absent those documents, those agreements, the rights still attach to the employer. With a consultant, not the case. And this is something that very often falls through the cracks, and we uncover it sometimes in the context of a negotiation or an acquisition or a litigation where a company hires a consultant, engages the service